So today we're looking at a stack of court documents from Orange County, a case called Ruvolo v. Walmart Corporation.
Right. And this is more than just a fight in a store. It's a fascinating look at a legal idea called premises liability.
Exactly. It's all about one question. How much responsibility does a business really have to protect you, its customer, when you're on their property?
It's the perfect way to understand something called the special relationship doctrine. Under California law, a business and its customers have this special relationship that basically says the business has to do something when things go south.
And this case really tests where that line is. I mean, if you get attacked by a total stranger while shopping, is the store on the hook for that?
That's the core question.
Okay, so let's set the scene. It's October 2016, Anaheim, California. A man named David Ruvolo goes into a Walmart on North Euclid Street.
He's just looking for a Laker hat, something totally normal.
And then, bam! Out of nowhere, he's tackled into a clothing carousel by a stranger. Ruvolo decides to sue Walmart, but he does something incredibly brave or risky.
He represents himself.
Yeah, he goes in propria persona or pro per. No fancy lawyers, just him against, a massive corporate defense firm.
Which is usually a disaster. But his argument was actually very sharp. He wasn't just suing because he got assaulted.
Right, that's the key. He was suing because of Walmart's reaction. Or, well, lack of one.
Exactly. He alleged that Walmart employees just stood there, watched the whole thing for several minutes, and didn't even call 911.
And of course, the defense argument is what you'd expect. They said this was a sudden, unprovoked criminal act.
That they were completely blindsided, couldn't have stopped it.
So in a case like this, the first thing you want to see is the tape, right? I mean, it's a Walmart. There are cameras everywhere.
You'd think so. But that's where we get into this whole issue of spoliation of evidence.
The destruction of evidence.
Yeah, right. So Walmart's asset protection guy, he gets up and testifies that their DVR system it runs on a loop. It automatically purges everything after 30 to 45 days.
And Ruvolo didn't file his formal report until day 56.
So by the time he officially asked for the video, the system had already taped over it. It was gone.
But wait, Ruvolo had a counter to that. He argued the police were there in November, way inside that 45-day window. Shouldn't that have triggered some kind of legal hold? A preservation mandate?
It's a really good point. But Walmart had a technical defense for that, too. They said the actual fight in the men's basics section was a deliberate blind spot.
A blind spot. Why?
For privacy. It was near the changing rooms. The asset protection associate testified that the police looked at the surrounding camera angles, saw nothing, and didn't ask for a copy. So the system just kept on purging.
Wow. So without the tape, it's just his word against theirs.
Yeah.
And Walmart was initially claiming they knew nothing about the incident at all.
Nothing. And that's a tough wall to break through for any lawyer, let alone someone representing himself.
Until the aha moment.
The star witness, Lee Sakala, he was a former manager at that very Walmart. He gets on the stand and he completely contradicts the company's story.
What did he say?
He testified that, yes, he did see Ruvolo that night. He saw him lift his shirt to show this really nasty injury, a deformed rib. And Sakala says he told him flat out, call the cops.
That's huge. That changes everything. The store is now officially on notice. They can't claim ignorance anymore.
Exactly. And even though the judge didn't let Ruvolo act as his own medical expert, the jury saw the physical injury. That testimony connects everything to the legal precedents here.
Let's talk about those. Delgado and Morris.
Yeah.
What did those cases actually require a store to do?
So Delgado v. Trax Bar and Grill is what establishes that special relationship we talked about. It creates a duty to protect.
Okay, but what does protect mean?
That's where Morrissey de la Torre comes in. It refines the duty. It says the store has to take minimally burdensome measures. They're not asking employees to be heroes and jump in.
Just do something simple.
Right. And under Morris, if a fight is happening in plain sight, the most minimally burdensome step is usually just picking up the phone and dialing 911.
Which seems to run right into those corporate policies that tell employees to stand back and observe, for their own safety.
And that was the central conflict. The Judge Schwarm, he denied Walmart's attempt to get the case thrown out. He ruled that if the jury believed Ruvolo's version of events, that this went on for minutes while employees watched, then they had a legal duty to call for help.
So the law trumps the employee handbook.
It's supposed to.
So in the end, the jury is left to decide if Walmart's failure to act was a substantial factor in the harm Ruvolo suffered.
It's an amazing legal web he managed to weave. all on his own. He got the judge to instruct the jury that they could assign fault not just to the attacker, but to Walmart, too.
It really makes you think about all this surveillance we live under. We assume the cameras are there to find the truth.
But it's an automated purge policy, can just erase the evidence before you even get a chance to file the paperwork. Where does the truth legally live?
A heavy thought. Thanks for joining this deep dive.